All right, we're going to go ahead and get started. We have a number of our members that are joining us through Teams, and since this is just a working session, we're not going to call roll, Ms. Jackson, so that we'll skip right past that part on the agenda that we have today. The first two meetings that we have had, we have covered the problems that have been discussed. The first through the commission report. The second committee meeting we had was we discussed the problems as determined by the Court of Criminal Appeals and the Supreme Court. Now, the purpose of today's meeting is to look into bills that have been filed, amendments, and proposals that have been done since the 2010 law had gone into place. And with that, always our favorite speaker, Mr. Jimmy Hintrican, you're going to walk us through this one as well?
All right, sounds good. Let's see here. Well, good morning, committee and members. So yes, as the chairman mentioned, we're going to talk about some of the amendments that we're going to walk through those very briefly, right, with what has happened since the major 2010 reforms, and then talk a little bit about two more recent proposals that dealt with some of the some major revisions to the code that kind of rose up in the wake of some of the things that we're talking about, like the study commission report and other matters. So yeah, we'll just dive right in and get going here. So, okay, the first slide, as you see, and you guys should have a copy of this for you to kind of walk through. If it's hard to see on the screen, you can look at it with the copy that's right in front of you. So yeah, the first thing we got is in 2011, right after the passage of these 2010 major reforms and revisions, you got the first thing there was Act 2011-259, which and I'm sorry about all the words here in the small screen for those of us in the audience. So what this bill did was kind of stabilize the annual appropriation to the State Ethics Commission, right? The language that was changed said that the appropriation to the State Ethics Commission shall not be less than 1/10 of 1% of the total state general fund unless approved by 2/3 of the full membership of both the House and the Senate. And I've got an extra little bullet point here talking about how the enacted language was designed to provide increased stability and funding for the Ethics Commission and the carrying out of its duties. So on one hand, you have some stabilization of some funding. There's a lot of, there's a lot more duties. There's a lot of change going on to the Ethics Commission. And on the other hand, you also have a little bit of kind of insulation from some, political retaliation or some emotions, knee-jerk reactions in the moment to what was coming out of the Ethics Commission, kind of protect it from that and protect its funding. So that was kind of the essence of that. And by the way, let me pause right here and say, as is usual from my previous PowerPoints, there's a lot of words on here, right? It contains a lot of words on all these slides, and I'm going to try my best not to read every single word, but the idea here is so that y'all have this tool and resource to use when we're outside of this meeting, if you want to, as a reference material of sorts, for you to be able to look back at it and kind of have a little bit more than just a few topical or summary words. You can kind of have a little bit more meat to look back on. So even if I don't cover all of it here, you can, obviously, hopefully it'll be a benefit going forward to have it as a resource. So with that being said, we'll kind of... And members, at any time, if you have a question or you want to ask Mr. Hintrican a question through this, members on Teams that are joining us, we've had the voice in the sky join us in the past. We can do that again this time. So if at any point you guys want to be recognized, just let us know. All right, so we'll keep going. So the next 2011 Act was HB 58, and that one was dealing with the public disclosure requirements for all public officials and candidates, right? So it added those for those that are employed directly by the state or the federal government, the ones that were under contract, some type of compensated contract with state or federal government, and those that are employed by a private company that received 50% or more of its revenue from the state. So any of those folks, plus their spouses, must disclose the compensation, the job description to the Ethics Commission within 30 days. So that's what that was about. It was another disclosure requirement that was added. The last one on this page is SB 222 from 2011, and that added the term corruptly to Section 7 in order to add some clarity to the general prohibition against the giving and receiving and soliciting things between legislators, principals, and public officials and public employees. So that's kind of Section 7, as a quick reminder, is like a general prohibition against giving, receiving, soliciting anything, right, for if it had a corrupt purpose. Now, before this act, it didn't use the term corruptly, it just said to influence, right, to influence anything. So there was some concern that was raised about, okay, that's a kind of a broad term, like whenever doesn't matter what group, it can be an individual, it could be an advocacy association, right, doesn't matter what they are, whenever they're trying to engage in conversations with you or, invite you to a conference or something like that, there's always, an idea to kind of promote some, public welfare, public issue topic. So out of that concern, they said, well, let's kind of clarify here that what we mean is corrupt influence. So that's the genesis, as I understand it, for that particular change in bill. And that was 2011. So going into 2012, a couple of acts here. This first one here, HB 466, added a definition of the term de minimis. And it defined it as $25 or less per occasion without no more than $50 per calendar year from a single provider. And it allowed the Ethics Commission to increase that, due to inflation once every 4 years or by administrative rule. Of course, the 2010 reforms originally did not have a definition of de minimis in there. And that, as some of you may remember, caused an issue with teachers and giving gifts to teachers. The act actually specifically struck the seasonal gift language that was originally in or previously in the ethics laws. So because it struck that and didn't have a definition of de minimis, there were some issues like that issue that folks thought, let's go ahead and be helpful and add and provide some actual amounts and definition of de minimis in there to help resolve that issue and some others. The next one, HB 136, in that same year was kind of some amendments to the statements of economic interest forms. It raised the income threshold from $50,000 to $75,000 before an individual be required to file. Now, there's other individuals, regardless of how much they make, are required to file statements of economic interests forms. But there's this general catch-all. If you make a certain amount, then you need to be filing these forms, and that adjusted that. And it also allowed that to be adjusted by the CPI, by the Ethics Commission, and it added a term supervisors to the list of folks that are required. So that's kind of that one. And, something interesting about that is there was a lot of folks that during this time period kind of were starting to have to file forms, like a lot of teachers, a lot of other, public servants out there that had crossed over that kind of barrier. And so now they're like, okay, let's figure out if there's a better threshold for folks to start filing. So that's where that came from. The genesis behind that, as I understand it. So that's 2012. Now we can move to 2013, and I am moving kind of fast, so I don't mind slowing down. I don't know if there's any questions. Y'all, please feel free to stop me. So now in 2013, we have SB 268, the first one on your list there. I think this is page 4 of your slides in your handout. So this act added language that required the Ethics Commission to exclude from any publicly accessible database personal identifying information that's part of statements of economic interest forms that are submitted to the Commission by any public official or public employee. You guys might recognize personally identifying information. In today's world, right, we hear a lot about that, about breaches from different places to get, places that are storing sensitive information. And that's kind of what that's getting at, is those sensitive information like Social Security numbers, driver's license numbers, the names of your children, those kinds of things. It required exclusion from posting on something that could be, obtained, publicly. And then the next act, which was in the following year in 2014, that I've got listed here, tweaked it added an additional requirement for, the first one was excluding the information in 2013. This act related to that previous act, but kind of clarified that not only is it excluded, but if there is anything that needs to be redacted, if there's any of that information in forms that were starting to be filed from the effective date of the 2013 act on forward, then redact that. So one, you exclude it. And my best kind of, the way I put the pieces together myself for these is maybe there was some question out there about whether you should have to exclude the entire statement of economic interest form if it had sensitive information in there, as opposed to just, no, you're able to actually redact it. Now you can make sure that these things are posted. That's how, as I understand it. Maybe there may be more to it than that. We can certainly track that down if folks are interested in that. So that was the 2014 SB 66. And now we move into SB 36. So this related to revolving door issues for elected officials. And the act did the following. It extended the 2-year moratorium for engaging in paid lobbying before, former legislative bodies from 2 years after leaving office to 2 years after the expiration of the elected term. We talked about this a little bit before, right? That, it's one thing if you leave in the middle of a 2-year term, and then you wait 2 years. What this was designed to do is to delay that, not for the rest of your term, plus an additional 2 years. And we touched on that in a previous slide in one of our previous meetings. It also broadened this moratorium, this kind of revolving door prohibition, from just one chamber of the legislature to the other chamber, to including both chambers. So if a Senate member left the Senate, a House member left the House, it included both chambers not to prohibit lobbying for 2 years, going back to that. And then thirdly, it prohibited paid lobbying at any level of state or local government during the entirety of the elected term. And that was actually a code, that was 23A section. And we've touched on that a little bit with some of the revolving doors issues that we've discussed in the past, because there was some language in there about not just lobbying, but otherwise representing clients, which the commission report talked about, the Ethics Commission has addressed as well, and kind of try to figure out, well, exactly what does that mean? That wasn't not necessarily intended to mean that a lawyer couldn't represent a client before a court, because it said any state, local, federal government, or any branch of government. So there was some clarification, some additional clarification that was needed in light of that. This is the bill that actually set those things up, though. So that was the tweak in 2014, SB 36. All right, so 2015 now, SB 242. So now this act did a lot of amending numerous provisions of the Fair Campaign Practices Act, but there were definitely some important clarifications and some important changes to the Ethics Commission and the ethics law side of things as well. So in addition to FCPA change, and I've included one of the examples that I remembered, because this was soon after I started here, was it kind of clarified when a contribution is received or not. It kind of tried to address some of those issues, and when expenditures are made for the purposes of filing requirements, timing requirements, and all sorts of things under the FCPA. But in addition to that, regarding the ethics laws, it expanded the jurisdiction of the Ethics Commission to include FCPA matters. Before this, that was not the case before this law. Including the authority to determine probable cause violations and refer for prosecutions, and the authority to review and modify civil penalties that are included under the FCPA for certain reporting violations. Additionally, it required one member of the Ethics Commission to have been an elected official for 2 terms. So yeah, those were the things that I kind of saw. Like, obviously, I didn't get into the details in the weeds on all the FCPA matters, but as far as ethics issues were concerned, those are the ones that I kind of saw and highlighted for our purposes this morning. The 2016 bill, SB 141. That tweaked, again, the topic of revolving door under Section 13D. And again, like I said, there's a lot of words in here. There's a lot of statutory references, but if you can want to use it as a reference guide, you can go back and look up these statutes particularly. So this act modified the revolving door moratorium for public employees. It specified that the moratorium applied to the person's former government entity in instances of consulting agreements or agency loans, in addition to direct employment. So what you had here was instances of somebody might technically not work for a government agency of any kind, right? They may actually work for some other institution, a different government entity, or some type of quasi-government private entity, or some type of private entity, but be working, in reality, a lot of their time, effort was spent working for a particular government agency. And so it was designed to kind of cover, no, wait a minute, this moratorium, even if technically you were employed by entity 1, but you were really working for government entity 2, then you can't go back and work before government entity 2. It was just kind of cover a potential loophole that folks thought, the legislature thought it should close. That's my understanding what that part was about. So part number 2 under here, it also established a limited exception for retired agency directors or division chiefs to be rehired under a contract for up to 3 months to assist the agency with the transition to a new director or chief, but there are certain compensation caps, and the ethics director approval is required. And, there's this general prohibition against, folks that were involved with procurements and, contracts out of their agency going right back to work for that, for different agencies. There's the general revolving door prohibition. This was to establish at least a limited exception for, okay, we want to hire back the person that just retired for a few months to help with the transition. So that's kind of the summary of that one. All right, so 2017. We're nearing the end of these post-2010 amendments. So we're in the second half now. HB 222 from 2017, similar to the previous act, this act also modified the revolving door moratorium and specifically allowed for municipalities to rehire retired firefighters and law enforcement officers to provide public safety services to the municipality. There were certain conditions in here. So again, this was a felt need to clarify an exception in this general revolving door ban, right, from being rehired or contracted with your former employer, right? So there were certain conditions that were put in here. A local law must be enacted that allows for the municipality to rehire the employee. And notice with a copy of that local law was to be provided to the ethics director. So that was a need that was brought up at the time, and those were the conditions that were added to the exception and passed in 2017. 2018, SB 267. This act broadened the Ethics Commission's jurisdiction and ability to resolve minor violations of the ethics laws, especially for public officials who committed violations that had limited damages or limited impact upon others. One of the key things here is that it had to have unanimous vote of the commission and consent by the Attorney General or District Attorney, like was still kind of required. And I believe, so under this, I think there was, minor violations were allowed previous to this, but what this did was take it from like a, if there was some type of inappropriate gain or inappropriate, then it took it from a $250 cap and increased it to $1,500. Or if there was a government loss, it increased it to $1,500. That's right. And it increased the penalty from $1,000 penalty to a $6,000 penalty plus restitution. And the idea here was there was a lot of potential issues that were not being addressed by the Ethics Commission or the Attorney General's office because they were just so small, but there were some significant issues that could be resolved. And so this was designed to kind of help, although it raised the cap from $250 of inappropriate gain or government loss to $1,500, that allowed them to actually address more issues administratively with less cost to the state. So anyway, that's kind of where the minor violations increases came from and broadened that jurisdiction over that issue. And then in 2018, HB 317, this act specified that economic development professionals are not automatically considered lobbyists for purposes of the ethics laws and the reporting requirements that come with that when engaging with the state and local government entities regarding existing economic incentives and economic development authorizations. It does not apply to activities requiring legislative action or some type of discretionary legislator authority, and there was a one-year sunset provision included. So, and this kind of arose because of, as I understand it, as an issue because of the 2010 amendments and our efforts to kind of capture this procurement lobbying and the definition of lobbying, this procurement issues. But, it could have turned out to apply to economic development reactions. And, from what I was told and understood at the time, the other states were using that against Alabama, saying these economic development procurement people and folks that were looking to keep their business plans confidential and have to engage in reporting requirements. And so this was designed to kind of address that issue, but it had a kind of a one-year sunset provision to kind of test it out and test the waters with it. And then in 2019, they took that same bill and just kind of took and reauthorized it without a sunset provision in it. But it was kind of a few technical clarifications, but basically this 2019 HB 289 just reauthorized that previous act without the sunset provision in it. Next, in 2019, we have HB 259. This act extended the deadline for candidate filings of statements of economic interest forms. Previously, the candidates were required to file these SEI forms simultaneously with their qualifying papers, and this act extended it to not more than 5 days after the qualifying papers were filed. And again, as I understand it, that was designed to not be a potential trap for people who were like first-time candidates maybe that didn't understand that they were going to have to file the SCI form at the same time they had qualifying papers filed. So just to kind of, I guess, be a little bit of a lighter burden for those, I think that was kind of the intent, but again, that's just as I understand it. And then lastly, 2023, SB 203. This act required the Ethics Commission to provide an alleged violator with a copy of the complaint and any evidence gathered by investigation from outside sources prior to the respondent's hearing before the commission. All evidence must also be provided to the Attorney General or the applicable district attorney upon a probable cause determination. And then additionally, the act specified that employee whistleblower protections apply regardless of who filed the complaint. So, you know, this law was in response to conversations and issues going around about whether exculpatory evidence, Brady law issues, y'all may have heard some of the conversations about that apply to individuals who are subjects of ethics complaints. So yeah, those are the amendments that have been enacted since then. Are there any questions before we get into some of the proposals that were not enacted, just bills that you were emailed and we're going to kind of touch on? Are there any questions before we switch into that?
Representative England?
Yeah, I just wanted to talk about that. A couple of things. First, the economic development part of that. One of the things that you mentioned was about the competition from other states. But also, I think one of the things that was mentioned was there was less of an incentive to do business in Alabama because there were certain people considered lobbyists. We had outlawed contingency fee contracts on lobbying. So if you were a lobbyist, you couldn't take a contingency fee. But if you make an exception for economic developers and site selectors and so forth, they can. So that was not requiring them to, not saying they're lobbyists, they could, you know, take a contingency fee, which was a big deal for, you know, some very rich people, especially folks who were building prisons. Also, and you mentioned something else. At some point, did we change? Because I know there were some questions about a statement of economic interest when you qualified to be a candidate. I think we took at one point when you would turn in your qualifying paperwork, and you would also turn in your statement of economic interest to the whatever party you were. But I think you still do that, but I think the party doesn't have any real authority in that anymore. I think you still have to go and seek, if say somebody didn't do the statement of economic interest, that in order to disqualify someone from the ballot, it would have to be, I think somebody else is responsible for that now. I don't think parties do that anymore.
Yeah, I'm not sure about it. It's a good question. Yeah, the only thing in the act itself, right? The language in the act was to literally switch it from simultaneously to 5 days. In that whichever one that was that we just went over.
I know we were
259.
For a while there was some people that were made famous by Secretary of State because, you know, he put out this list of folks who didn't file their forms. But there's obviously just two distinctions. One, if you're first time running and you're filing versus you're already a candidate and then you file, it's two different purposes there. So one doesn't disqualify you, but potentially another one could. I'm just trying to figure out if we had changed that at some point.
So, all right, so if I understand your question, and I'll just track it down for you because I think it's an interesting question, is, okay, let's say we changed the filing date. We gave an additional 5 days before, you know, permissible 5 days. What does that do to qualify? Who has the authority, or who's the governing authority over, like, well, does that disqualify you, and who makes that decision? Yeah. Right.
Yeah. I mean, I guess it's not really relevant to what we're talking about, but we can talk about that offline.
Right. Is it the political parties that can keep you off the ballot if there's a violation of that 5 day requirement, or is it the Secretary of State?
I don't know. I don't remember. Because I don't know who has I don't know if they took that authority away from, I don't know. So we'll have to figure that out. Anyway.
I'd have to double check.
Representative Jackson?
Hey,
Let me do this way first before we go to who's speaking online. Representative Bolton.
Thank you, Jimmy, for the update. Hey, I got one question I've got about the Secretary of State versus the Ethics Commission dealing with FCPA reporting. Is there, and going back in time, is there a reason why we split those duties, or while it's not all one or the other, where we report over to the Secretary of State's office and then any kind of violations are then referred over to ethics, or why do we have that division there?
I'm guessing, but I want to make sure I understand your question. So your question is, all right, so we have the Secretary of State and dealing with FCPA matters. We have the Ethics Commission dealing with ethics matters, right? And we have attorney generals and district attorneys that are dealing with both of those matters, right? And so are you asking what the genesis was of moving some of those FCPA matters into the Ethics Commission?
Well, I certainly understand the division between the attorney general and DA. That's okay. Somebody's made a decision, a determination, somebody's going to be prosecuted, then it goes to prosecution services. But the reporting, and don't get me wrong, the system is run very, very nice. The reporting is over at the SOS right now. And then any kind of violations are then referred to ethics. Is there a reason? What was the original reason why we didn't do that? I got caught in that loop here recently, and it took quite some time I never got referred to ethics, but I had filed all my appropriate forms, and it took me an unusual amount of communication to get them to, number one, acknowledge that I was in compliance, and number two, never admit that they had made a mistake. But I do have the paperwork showing that I did, but I'm just wondering why you do that one place here and then it's referred over to the other. It seems like it could go all to one.
Yeah, I think that's a good question. I've marked it down to follow up with you and also to track down some more specific answers,
Sure.
right?
I think you and me had a discussion about that matter.
That's right.
Yeah,
and
that's right.
That's exactly right. I think part of that is a policy decision. I hesitate to say anything like off the top of my head if I'm not
I don't know if it needs to be changed. I was just curious.
Some of that change could have been the fact that the Ethics Commission was set up to offer like advisory opinions is what they did, right? So, and those two are close cousins, if not brother and sister type related with how their interaction between candidates, elected officials, and elected officials who continue to be candidates, right? So there's all kinds of bleeding issues that bleed together there. But that's just me off the top of my head. I'm happy to, I've written it down to kind of go into a little bit more depth on that and get back to you.
We'll get back later.
Sure. Good questions.
Representative Jackson.
Thank you, Mr. Chairman. I want to go back to the statement of economic interest form. That was an issue in Clark County several elections back, where the county clerk, two people running for clerk, one person didn't file their paperwork, and that person finally won the election, and then there was a complaint because the paperwork was not turned in. But they still seated her as the clerk. So I hope that we can make sure that if we're going to use the law, let it be meaningful and let it be to the point where the paper that is written on is not just paper, that we're going to execute what is written. If that's disqualifying for you, you didn't turn in your paperwork, and I had that opportunity to say that to the person, then you're disqualified. But it didn't happen that way. So I'll make sure that we have laws that are meaningful, because people just forget about. They don't want to adhere to laws anymore. But we must bring back the rule of law. That's what I'm. Thank you, sir.
Sure. So it's. Again, I'm trying to keep track of the notes for follow-up, but it sounds like what I'm hearing you say is like, okay, with regard to statement of economic interest requirements or other kind of requirements for qualifying requirements, right? Requirements for running for office, for maintaining, whatever this is, these qualifying issues. Statement of economic interest. So, A, what are those requirements, and what are the consequences for failure to do those things? I have some clear lines, like, okay, and make it mean something. That's what I wrote down, right? Right? Am I hearing you right? Like, okay, what is the consequence of not filing this?
What are the consequences for not filing? If you fail the consequence, then you lose the opportunity to serve.
Right.
Or you have an opportunity to rectify why you didn't do it. Don't just because I don't know. What is happening? The party has interfered with the law. And the party overruled what the law is, and nobody hold up the law. Go back to law and order. That's all we're saying. You got it written down right, yes.
And I think what you bring up is actually a very interesting topic to discuss. Like, it's something that kind of pops up a lot that I didn't think about a whole lot until I got here, to work for the legislature. Is there's very much two different areas and issues underneath a law, right? Especially if it's a law preventing something, right?
Yes, right.
Don't do X. Well, that's a completely separate topic from, well, what happens if you do X, right? Those are two different things. And sometimes statutes don't always clearly, address, it just says don't do X, but there's another topic here, right? Well, what if you do it, right? What if you do the X? What are the consequences? And those are two different things to think through. And that's important for y'all that we've brought that up a little bit. And we're actually going to touch on some of that going forward with some of these, some of these issues, some of the all right, well, what are these penalty structures that we're looking at? And do you want to change it? A lot of this is going to be policy, right? It depends on what you guys want to do. But anyway, yes, that's a good point. You got it written down. We can follow up as much as you want on that.
Thank you.
All right, we had somebody up, Representative Travis.
I guess the question I had was referencing, I guess, the 212 law where it says on the Ethics Commission may increase for inflation according to CPI once every 4 years on, I guess, de minimis values. How do we know is that being, because, right now we're dealing with inflation. It's a big issue. Is it 4 years, if you understand what I'm trying to figure out.
I know I do. The Ethics Commission actually recently updated and sent out an information blast. At least I remember getting it, right, and passing on some other folks about what the updated de minimis requirements are. And so, yeah, they update folks regularly. And I know they'd be willing to send it to you directly, send it to us as to something to send back out to y'all as a reminder. Or maybe it's a good point to just figure out what a helpful way for the Ethics Commission to communicate that to teachers, to firefighters, to janitors, to the legislators, to city council people, right? To all these folks. I mean, it's a good point because it's not so consistent that it's on people's minds a lot, right? If it only and I don't remember what the administrative rule is off the top of my head, but it's a good thing, right? If it's out of sight or out of mind for 3 years, and you may not be thinking to look for it, right, in that 4th year, that kind of thing. And I may be, like, they may do it more regularly than that. I don't want to misspeak, but I'll just follow up on that and figure out.
And
I believe
the question is, and also I thought, maybe it's one of those things that maybe need to be done annually, because we look at where inflation has been in this last couple of years, it has a great impact. So 4 years, you get the value of that, and what people dealing with stuff. So that's the other question I have.
Yeah, the price of some milk and eggs went from $2 to $8 in 2 years, right? Not 8 years or 4 years. So yeah, it's a good point.
I believe that $25 is $32 now, based in CPI for inflation where we are through here. We had someone online that had a comment. Was there a representative online that wanted to speak?
This is Corey. Can you hear me?
Yes, we can hear you.
I think my question was answered later on in the discussion, so I'm good.
Thank you, Representative Harbison. All right, so that's kind of got us to how we got here today with what's actually in the law and how we got through here. Now, if we can, I want to talk about some of the proposals that have been proposed in the last couple of years to address where we go forward.
Okay, so 2 bills here we want to talk about. 2 different bills with kind of 2 different approaches to some of these, to some of these issues that we've been talking about, going back to the study commission report and the case that we studied, right? Some of the questions that the Supreme Court raised. So the first one we want to talk about is HB 432. And then SB 230 from 2019. And these bills kind of take 2 different approaches to that, but address, at least generally, some of these same issues. The first one I'm going to go over just as a summary of a bunch of different slides I'm going to go over. This is some of the topics that 432, and I chose this one first because it hit on a lot of these study commission issues that were addressed. Conflicts of interest, definition of a principal, gift bans, revolving door. We discussed these, somewhat at length from the study commission report in previous meetings. The compensation exclusion, we studied that from the ex parte Hubbard case, right? And what are the issues that come from that? What are the potential? Is it potentially overbroad? There were some, other issues about being potentially narrow. We've talked about penalty structures, especially when it involves the gift ban, right? And then jurisdictional issues, kind of like Representative Bolton, what you were kind of hinting at right now is, okay, in what areas do we have concurrent jurisdictional issues as opposed to exclusive jurisdiction issues? So that's just kind of a summary of the slides I'm about to hit on. So first, I'll just tackle this part first, right? The conflicts of interest. This is how HB 432 proposed to address this. So you guys may remember from our previous discussions from the study commission report and from the Hubbard case, right? There's two different definitions of conflict of interest. One is a more broad, general definition of conflict of interest, and still was very much tied to finances, though, right? Being materially affected and uniquely impacted by certain financial transactions or personal gain that would come from something. The other was a little bit more tied to ownership in a company or being on the board of directors or being an employee of a company. And that was the one that was in 5F. So this bill was introduced and proposed to change that by essentially adopting a shortened version of the general conflict of interest definition that was in the definition sections of the ethics laws, and struck that shorter 5F definition that was contained in the statute that actually had the prohibition. Right, so the only time the conflict of interest term was used in the ethics laws right now is when voting. You cannot vote under a conflict of interest, and that code section had 5F connected with it. It was kind of a shorter definition. So this one struck that 5F definition and adopted a shorter version of the general definition, which focused on, on material financial, sorry, there's a misspelled word there, focused on material financial interests of public officials and employees and their families and businesses, where their official actions would, uniquely benefit them differently than other members of the applicable class to which they belong. And it extended, and this comes from the study commission report, it extended the restriction against conflict of interest from just voting on matters under conflict of interest to taking any official action. And like I said, this applies to city councils, right? It applies to county commissions, it applies to any legislative body whatsoever. So here was, like I said, again, a lot of words, but I wanted to kind of have, if you use this as a reference material, I want you to be able to kind of go back and see the differences. It kind of cut out some of the more general language about private interests and public interests, and just cut straight to the heart of what is materially affecting the person's financial interests, right, or those of their family members or business with which they're associated. So another issue was the definition of a principle, right? So it addressed the overly broad versus overly narrow concerns, or attempted to, that were identified in the 2019 report by proposing the following: to expand the definition of a principle beyond, and just, I don't have it written down, but y'all remember, right? It's an individual or a business that hires or employs a lobbyist, right? That's the current definition for principal. So it expanded that to include an individual acting on behalf of a principal who has the responsibility and authority to fire the lobbyist or to control the positions or directives of the lobbyist's activities and the manner in which those activities are carried out. So a lot of these issues were brought up in the, in the study commission report. Was addressed in the case that we went over. And so, anyway, this was kind of a way to grab that middle ground of folks that were was at the heart of some of these things. It limited the scope of this expansion, however, to expressly exclude individuals that are merely lending their subject matter expertise or participating in the process of determining the policy positions of the principal, which, in my opinion, could be like, so members of a board, right? Members that are just saying, okay, this is what we want our company's position to be, but not saying, well, this is how you're going to do it, and this is the lobbyist we're going to hire, that kind of thing, but just having some kind of say in that. At least that was my understanding of it. So that's how this particular bill decided to try to approach the definition of a principal issue that was brought up in the commission report and other things. So the gift ban, right? And by the way, I apologize if some of there's some pretty funny pictures I have in here, right? The last thing I wanted in giving a presentation to the Ethics Commission, okay, was to accidentally grab some copyrighted image off of Google, right, or Bing, and put it in here, right, unknowingly. So I stuck with whatever Microsoft stock images were, right? So that's the best I could come up with, right, with a picture of a gift. So I apologize that, especially if you look back at this after we're done here, right, for any kind of referencing. So anyway, all right, so getting back to the gift ban, right? So the bill struck out the term thing of value and its 18 exclusions, and instead, so it took away the definition, but instead it modified 5.1. And 5.1 is the current law that we have on the books, right, that prohibits the giving, receiving, soliciting, right, of things of value. And instead of using the term thing of value, it just said you can't give anything. Receive, lobby, right, depending on whether you're the lobbyist, whether you're the clerical person, right, whether you're the public employee, whether you're the teacher, whether you're the firefighter, whether you're the legislator, whether you're, the councilman, that kind of thing, or whether you're the lobbyist or the principal. No giving, soliciting, receiving anything unless it fell under an exception. So it took out the definition and just said anything. It took the 18 exceptions, the current exceptions to a thing of value, and simplified and trimmed them down to 9. It eliminated the full value exclusion, right? That was the one that was discussed in the case, right? Who's the recipient of the value? Who's the one that pays? Who's the one that receives? And what does it mean to pay? Can it be money? Can it be other things? It struck that part, and it also revised and expanded the compensation exclusion, and it revised the penalty structure for gift ban violations. So here, see on the next slide, is the 9 exceptions to the ban on anything under 5.1. This bill proposed to address it by coming up with the banning anything with 9 exceptions, and those 9 exceptions included these things right here: campaign contributions, ordinary business transactions, terms generally available to similarly situated individuals, gifts based on a family relationship, de minimis items, travel and registration expenses for educational functions when the principal or lobbyist is a sponsor, friendship gifts, as long as there's no specific interest that friend has with you before, your government activities, anything paid by a government entity, number 7 there, anything paid by a government entity or association with the state or the local government as pays dues for, employment compensation, business relationships, right, that whole thing we've discussed before. Regarding food and beverages, can generally be provided at widely attended events, and that's my term. They actually don't use the term widely attended events, but it's, in essence, it's very similar to what the old definition of a widely attended event is, right? So, numerous people being there with a variety of different positions. So that can, generally be provided for at widely attended events, including whether that's just a full legislative body, a full city council was invited, a full group of folks, a full committee, a legislative committee. And then outside of those kind of widely attended events, any other occasion, it kept that kind of $25 cap, $150 a year limit for that. I will say that it also, that there was a conversations that we've had about family relationships and friend relationships, gifts. The previous and the current law mentions circumstances which make it clear that it's based on a family relationship and not based on official interests, or based on a friendship and not based on official activities, right, or for public reasons. This bill proposed to strike that circumstances would make it clear language, which in essence, and this is just kind of the way that I phrase it, right, in essence that was and this is, it's a little bit, it's hyperbole, so I'm going to apologize in advance, right? But it's almost kind of like you're guilty until proven innocent with that language, right? If you have to have circumstances that make it clear that it's a family relationship and not related to business. So you have to, and that was brought up in the Ex parte Hubbard case, right? When it as a part of the unrelated term. So this struck that language out. So it took out the whole circumstance to make it clear and just simply said, instead, it's the other way around. It's gifts on a family relationship unless it's clear that it's actually for an official relationship. So it kind of helped the exclusions be a little bit easier to apply. At least that was my understanding of the intent. Okay, so going into the compensation exclusion. This is how it proposed to deal with employment, right? A lot of folks in our legislature are employed. Sometimes employment changes. How do you handle that, especially if it somehow involves a principal, primarily, sometimes a lobbyist, right? So this is how it proposed to do with that. Business relationships established prior to entry into public service are permitted as long as it's unrelated, and that's the term unrelated is under current law too, right? And compensation does not create a conflict of interest. Now, I've tried to keep it short with the slides here. Compensation does not create a conflict of interest. It doesn't mean that just because there's a potential conflict of interest, you can't take anything, like in the case of a legislative body. I think the way I read that language was if it was like irreconcilable conflicts of interest, things that were going to be constantly or regularly put before you that would put you in a position regularly or in a likelihood of putting you in positions where it would be hard for you to carry out your public service in light of the conflicts. So I didn't take that as an absolute ban on one single conflict of interest, but to allow for, you know, the occasional recusal, but just not something that was kind of, you know, not a barrier, right? The speed bumps may be okay, but not a barriers. So that's prior to entering into public service. If there's a business change or relationship that's established after an entry into public service, that's permitted as well. And this is some of the things that they included the unrelated to the official position and doesn't create conflicts of interest. And additionally, so this is there's obviously there's more requirements here for after public service. Number 3, the employee or the contractor is reasonably qualified to perform the services. The compensation is substantially similar to customary private sector compensation. The business is unlikely to have specific interests before the public servant, and the compensation does not involve fundraising that's basically contingent upon how much money you raise. Those were the ones that are included in that. For the sake of time, I'm going to keep going. So it also included a revised penalty structure for the gift ban violations. Y'all may remember the study commission report mentioned how, you know, the potential issues and pitfalls that could come from spending more than spending $30 on somebody instead of $25 on somebody, and just kind of the penalty, the existing penalty structure, whether kind of a more staggered approach would be helpful. So. Under this bill, the way they decided to do it, so currently you have a general penalty structure for all violations. Intentional violations or Class B felony.
Mr. Inchkin, I'm sorry. I hate to bother you.
Sure.
It's the season for entertainment and spooky activities. But we have a guest in the chamber, and I really.
Is it the gorilla in the room?
There's you know.
I thought it was me.
Usually the phrase is an elephant in the room, but right now there's a gorilla in the room. I feel like we're all safe, that there's no threats here, that this isn't some sort of. I don't see security looking for us, but. It's that season, everyone. We've been greeted by a gorilla in this ethics committee meeting. Sorry, Mr. Inchkin, I appreciate your time.
No, actually, thank you for stopping, because I saw it out of the corner of my eye, and I was like, what do you do in this scenario, right? And at what point does what's going on behind me make me turn around, right, to see what's going on? So, no, thank you. I appreciate that. All right, so, again, backing up. So we have in the ethics laws, like generally for the standard penalty structure, right, for intentional violations and Class B felonies. Standard violations, in other words, not intentional violations, Class A misdemeanor. Disclosure reporting violations are Class A misdemeanors, and there's the minor violations that we talked about before. The $1,500, just for your reference for later, the $1,500 underneath that cap, that's really actually for public officials. For public employees, there's actually a little bit more flexibility if there was not a, you know, depending on if there's very little economic gain or if there's nobody else involved. In other words, there's a lot more circumstances beyond just a $1,500 cap that could allow a minor violation to be resolved administratively for public employees.
Representative Jackson.
I just had a question. Is there a distinction between elected officials and public officials?
Not to my knowledge, there's not when it comes to the penalties for violations. There might be some for or maybe it's potentially for revolving door issues, and I might be confusing proposed changes to the ethics laws versus the existing law, but the only thing I'm aware of that could be a potential differentiation between elected officials and appointed officials is revolving door issues, not penalty structures. Okay. So what this bill did is, so it substituted the penalty structure under the current system for a graduated penalty structure with civil penalties allowed for, and this is only in the context of gift ban violations. So under this HB 432, this revised proposal, a first offense would be a civil penalty, and this is a revised penalty for gift ban violations. A first offense would be, a civil penalty up to $3,000, second offense, $6,000, third offense, Class A misdemeanor, but anything intentional would still be a Class B felony. All right, so revolving doors issues. I could spend real short on this because it basically just addressed a lot of what was brought up in that study commission report that you already have copies of. And some of those examples were distinguishing between appointed, there we go, just Representative Jackson, what you just mentioned, appointed officials versus elected officials, a shorter time frame for appointed officials. It struck that vague, otherwise represent clients phrase from 23A. It clearly allows for government agencies to rehire former employees and clearly allows for, public-to-public transfers, meaning like, okay, an employee of one government sector goes to work for another government sector. We're all under the umbrella of working for the people of the state, so there was a minimal concern there. It also bifurcated 23A's restriction against lobbying other government entities into statewide versus local, meaning that instead of somebody who was an elected official at a local level, they just couldn't lobby any local government agency or entity in their locality, but otherwise would be okay. Statewide officials have maintained a continued statewide ban against lobbying at any level of government throughout the state. So that was the revolving doors issues for those. Concurrent jurisdiction considerations. Okay, we touched on this a little bit, but actually not that much, but it's important in this piece of legislation, and it's also addressed in the next one. So currently, both the Ethics Commission and the AGs and the district attorneys generally have jurisdiction to investigate ethics and FCPA violations independent of one another. Now, only attorney generals and district attorneys can prosecute, right? You've got this reminder about the minor violations there. It could be administratively resolved by the Ethics Commission with full agreement with the AG or the applicable DA. But there's this, and by concurrent jurisdiction, we mean like shared jurisdiction. That's what I mean, shared jurisdiction. It kind of bleeds over one into the other. This particular bill chose to try to address that by mandating that the Attorney General or the applicable DA could not bring a case before a grand jury for an ethics violation unless the Ethics Commission first made a probable cause determination. It also required the AGs and DAs and other law enforcement agencies to notify and cooperate with the Ethics Commission regarding any investigation they were undertaking. And lastly there, it gave the Ethics Commission the authority to issue public reprimands and private censures for first-time violations if there was no financial gain. So those are some kind of major proposed changes, even though they're very briefly stated, there were some major proposed changes about trying to figure out these jurisdictional issues and clarity of who prosecutes, who investigates, and what the standards are. Okay, so I know I'm running short on time now, so I'm gonna keep going, but just cut me off anytime, right, Mr. Chairman, because we're just now getting into SB 230.
We don't have a ton of time, but we have a ton. We can get through this before we adjourn.
Okay, so switching into this other bill, SB 230, these are just the topics that are addressed in here, conflicts of interest, jurisdictional issues. You can see that, and you can use it for reference later. So what SB 230 took a different approach in several key areas than what the previous bill did, HB 432, and how this approached these issues are as follows. For conflicts of interest, it just similar to the other one, it essentially adopted the general, broader conflict of interest definition in the current ethics code. We've talked a little bit about Section 7, about not giving or receiving anything for a corrupt purpose. Well, this bill incorporated those provisions into the crime of bribery in the criminal code and struck it from the ethics code. But not just this issue. It actually addressed concurrent jurisdictional issues in a much bigger way. It actually proposed to transfer Section 5 and Section 7, which is the meat of the criminal violation, right? That's the no use of office for personal gain, no use of equipment and facilities for personal use, soliciting things of value from subordinates or somebody that you regulate or inspect, voting under a conflict of interest, executive branch lobbying for state legislators, and receiving or soliciting anything for a corrupt purpose, right? Took all those and transferred them to the criminal code, right, to Title 13A from the ethics code. I've got a couple of slides in here that kind of illustrate what it is that we're trying to kind of highlight here. As you can see, and it's mainly going to be good for just kind of reference. I won't spend too much time on it here. You see these issues, right, in the big circle: criminal violations, minor violations, gift bans, personal gain reporting requirements, registration requirements for lobbyists, training requirements from the Ethics Commission, FCPA issues, use of confidential information. All those, there's at some level, at least at the investigatory level and providing opinions, concurrent shared jurisdiction between the Attorney General and applicable district attorneys and the Ethics Commission. So how this bill changed, just as a visual, this is how this bill proposed to change it up, right? And that is, I believe I am now on slide 23 in your handout. I don't know if there's numbers on your handouts, I'm sorry about that, but it's this page right here. This is kind of the category, right? The silos, what these issues were put under. The Ethics Commission kept disclosure reporting requirements, training requirements, FCPA issues, prohibited use of confidential info, notice requirements for representing clients before government bodies, awarding of contracts to public officials and employees that are paid by state funds, and attorney generals and district attorneys would have the investigation and prosecutorial jurisdiction over use of office for personal gain, bribery and corrupt exchanges, use of office equipment or facilities for personal use, soliciting things of value from a person the employer, or public official regularly inspects, voting under conflicts of interest, and executive branch lobbying. So that's what that looked like under this bill. It revised the penalty structure for that. For the criminal violations, what I've done is I've repeated the basic penalty structure that we just talked about. But now for the criminal violations, it proposed to add some knowing elements instead of intentionality. If it's under 6,000, it's a Class A misdemeanor. Between 6 and 100,000 is a Class C felony, and then more than 100,000 is a Class B felony. So it used a staggered approach. With ethics code violations, it added a civil element for a $6,000 civil penalty for reporting and disclosure violations. False statements and complaints were Class A misdemeanors. Probable cause findings by the Ethics Commission for criminal violations was a continued referral to the DA for prosecution. And then next, the other major change and different approach that this bill took from the previous bill we looked at was how to handle things of value and the gift man approach. So as we mentioned, section 5.1 prohibits lobbyists and principals from offering or providing a thing of value to public officials, employees, or family members, and public officials and employees cannot solicit or receive those things. Well, this act substituted the current gift ban approach for a total disclosure requirement. It proposed striking section 5.1 and a misdisclosure requirements, which is under section 19, to include the name, date, and cost of anything of value provided and their families. So it still maintains the definitions of gift of value, and we'll get into some potential changes, but instead of prohibiting it, it substituted that approach for a total disclosure. So right now, the law, under the current law, lobbyists report anything that they were given that was not a thing of value. This would, instead of that, it changes the report. So now the report shows anything they give, anything of value that they give, they have to report anything and everything, every dollar. So, so that's a big change that this bill in particular chose in contrast to the previous bill. It also addressed the representing clients versus lobbying ambiguity. It kind of clarified this prohibition does not apply to representing clients in the person's private practice or profession, so long as it is outside the official's government body and unrelated to any official duties. It tweaked some definitions. It simplified the thing of value language and trimmed the exceptions from 18 down to 13. You remember from the case we went over, there was these questions that the Supreme Court raised about what does it mean to be pays and who's the recipient. And adopted basically what the Supreme Court's interpretation in that case was the full value exception means any exchange for full value. It tweaked the hospitality exemptions, meals and special events, just kind of consolidated those to fewer categories and opened it up. Instead of having different definitions of what is a widely attended event or an educational function, it's basically any time 20 more public employees are invited. That's how it tried to handle that. It's very similar to the other bill when it came to revolving door issues, and I'm going to skip that because we've already talked about that, and that's what I got. I'm happy to answer any other questions or jot down notes to track them down, right? Because it's...
Any questions for Mr. Entrican? Well,
I have a question.
yes.
Okay, it's Corey. So, Jimmy, you spoke a little bit about penalties for filing false reports. And what did you say, a $6,000 civil penalty? Was that correct?
I believe so. I'm trying to back up to it, Representative Harbison. There it is. That's what SB 230
Okay.
recommended.
Okay, so I guess my question is, does it require them to do this if someone files a false report? I mean, when it's obvious that it was false, or does it just give them that option? Because this goes into, I think maybe it was Mr. Jackson talking about, somebody a while ago talking about, it does no good to have it in law, if you don't have anything to back it up. And I just wonder, does it say they may or they must?
I believe that, first of all, it's up to 6,000. So I know there's a variation in there. My recollection,
yeah.
although I'll get back to you, is that yes, I don't think they have the authority under this bill proposal to not do anything about it. It's just, but they do have the authority to determine whether it should be less than $6,000 in a civil penalty or not, if that makes any sense.
I understand.
Yeah.
And that's fine. 6,000 is high, I guess, unless you're ruining somebody's life, and then it's not near enough, But I just wondered about that. I think that if it's obvious what's going on, I don't think they should have a choice but to go after them for it.
I'm going to mark that down because, well, regardless of what this bill proposes, if that's an issue that the committee wants to address in a future clarification, that's certainly an issue to bring up and try to remember. So I'm going to mark that down that you raised that issue up, Representative Harbison.
Well, that's just mine. I mean, everybody else may feel a little different. I don't know, but I just think that, we've had one member I know that's had a hard time over the past few years, and when you're running for election and there's a complaint filed with the Ethics Commission, and the newspaper is notified before the ink's even dried from the fax machine at the ethics office or however they send it in. I mean, that's, and then they find that it's not a legit complaint. That isn't a problem. It's a problem.
Thank you, Mr. Harbison. I want to thank you, Mr. Entrican, for your past 3 meetings, the past 3 months. I know how much effort and time you have put in this. I kind of want to let the committee be aware of where we're going from here. These past 3 months have been the informative discussions that Mr. Entrican has led for 3 hours now, with a deep dive into ethics each time. And I'm really, really appreciative for your knowledge, for your insight, for your ability to kind of break this down and kind of leave it where we can get it. So thank you very much for that.
My pleasure.
Next month, on November the 30th, we're going to have a special guest come in from the American Law Institute that handles ethics laws to talk about, I'm a big proponent of not reinventing the wheel. There's 49 other states, including the federal government. We're going to be able to ask him questions of how do other states do this? What is this considered? Are we out of whack on things? So I'd ask members of the committee to be prepared to have a discussion at 1 p.m. on November the 30th with the guy from the American Law Institute to be. He's gracious enough to fly down here to do our time. So if you can, to be here for that.
Richard Briffault.
Richard Briffault, yes, a professor active with the American Law Institute. So we'll be able to get into some of the philosophical questions and some of the questions about what he would like to do. If y'all have any questions you're thinking about between now and then, if you want me to send them to him so that way he can be prepared with an answer for some of the questions, to look into what other states are doing, how do we compare, and things along that nature. That will leave us. We're not going to have a meeting in December. It's Christmas. I think we'll let the staff actually enjoy the holidays for Christmas. My intention is that in the beginning of January, we will have a bill for the committee to look at for a draft. It will not be a bill that is filed. It will be a bill that is drafted to give the committee to look into it, see what they can come up with, see if there's any input from the committee, see if there's anything that you would like to add, what you like, what you don't like, really make this a collaborative effort through here. We'll come back and have a second meeting towards the end of January where we've put those recommendations in or talked about the recommendations before we actually file a bill. And the plan at that time is at the end of January, the beginning of February, to actually have a bill filed ready to go in this process so we can have this through here. I want to thank the committee members for their time. I know this has been long. I know this has been drawn out, but I felt it was important. We have a lot of members who weren't on this committee in the past, and I felt like it was important to get people up to speed on how we got to where we are today and which path has been offered to go forward. So I told you from the beginning when I first took the gavel, this is a working committee. We have worked, I want to commend every one of the members that have been here personally to drive down, that have taken the time to do it over Teams, and sitting down and listened and learned through this process to really get educated on ethics in Alabama. And now's the time we'll start to get the ball rolling in the legislative process, and we'll do a little bit less listening after the Professor Brefalt comes in and do a little bit more of, I know we like to talk and discuss issues, so we'll be able to do that a little bit more with an actual bill when we come back. Representative Jackson.
Just to commend you, Mr. Chairman, for opening up this opportunity to make things balanced in this state. And we believe and understand that moving forward, things got to be listed and there got to be consequences for those things that we violate. We got to carry that in a manner where it's going to be appropriate, not trying to ban people, not trying to do away with, but to make things fair and balanced. That's what we're trying to do. Thank you so much.
Thank you for the kind words, Representative Jackson. Anyone else? All right, members, I am going to adjourn the meeting then. Thank you very much.